the things that we'll be looking at are communications with client, how to make sure that these are correct. Client care letter is absolutely vital to make sure that that's full, detailed, and concise. That you use a template for a report to the client, that you take full and unambiguous instructions from the client, particularly, as we will see in some of these cases, if it's an established client, because often there can be a misunderstanding between an established client and the solicitor or advisor as to what they actually intended. And make sure that your emails, ongoing emails, letters, correspondence of any type is accurately recorded and retained. Make sure that advice is timely. If you're dealing with promotional agreements, option agreements, pre-application discussions before the planning application, unilateral undertakings, certainly make sure with pre-application discussions that things like conditions attached to the planning permission are looked at very carefully, because there's always a need to agree conditions before the planning permission is agreed by the local planning authority. And make sure that you as a lawyer are involved with any of the discussions that may take place. Now, I know that can be a problem. I do appreciate, particularly in today's world, that clients are often very cost conscious, in fact, always cost conscious. So they may be uncertain as to whether or not you really need to be involved right at the beginning. But do make it clear to them it's better to be involved at the beginning than have a difficulty partway through, which would involve more of your time and therefore more costs. So we look at planning permissions and conditions. If there's no planning permission, or if you're uncertain as to what the situation is regarding the legality of the use of the property, should you obtain a certificate of lawfulness of established use of existing use and development, that's a CLUID, or should you get a certificate of lawfulness of proposed use and development under section 192? Or should you go straight in to get a planning permission? Drafting section 106 agreements, it's often obviously essential that planners and lawyers are involved, particularly with meetings beforehand to discuss complicated section 106 agreement terms with the local planning authority. Try not to get sucked into a war of words. Sometimes the local authority will be very prescriptive as to what they think they should have in the section 106 agreement, whereas what you want may differ from that. Just be careful to negotiate it sensibly rather than have a battle with the local authority. We look quickly at judicial review and appeals, and as I say, we look at the proposed reforms to be aware of for your clients.